Okay, now next, what we'll do is we're going to have Christina Lucero introduce Keith Harper, and after that, we will have Keith Harper as our guest speaker and have him do what he's best at and express what his experience was working closely with Eloise. And I'm just once again extremely honored that Keith has agreed to come here. It's such an honor for us to be in his presence. So here's Christina.
Good afternoon. Thank you everyone for being here. A couple of announcements before I do the introduction for Keith. For those attorneys online, there will be a password similar to what we've done in the past to get the CLE credit. It is pending approval. If you are an attorney in the room looking for a CLE credit, there's a sign-in sheet floating around over here on the table. So if you can put your name and your bar number on there, when we get that approval, we can get your credit for you. My name is Christina Lucero. I'm an enrolled member of the Sycam Nation, which is from Vancouver Island. And I am pleased to introduce to you Keith M. Harper, who is a member of the Cherokee Nation of Oklahoma and one of the lead counsel in the Cobell versus Salazar case, the historic trust funds case that exposed over a century of federal mismanagement of Indian trust assets. That litigation ultimately resulted in a $3.4 billion settlement, the largest settlement of a lawsuit against the United States in history. Ambassador Harper wasn't just in the room, he helped drive the strategy, the negotiation posture, and the final accountability moment. He went on to serve as the United States Ambassador of the United Nations Human Rights Council in Geneva, the first Native American ever to serve as a U.S. ambassador. He now practices law at Jenner and Block, where he continues to work on Native American law, human rights, and complex litigation that sits right at the intersection of sovereignty, justice, and federal power. Please help me welcome Ambassador Keith Harper.
Well, thank you, Christina, for the both the invitation and the introduction, and thank you for having me here today to speak about one of the things that is a favorite topic, which is Eloise Cobell and her legacy, and what she means and what she did. So I thought I would talk about this in four parts, because I think you can only understand Eloise's work if you understand all four parts of these. And so the first part I want to talk about is what led to the Cobell case. What was the conditions that gave rise to the Cobell case? What problem was it trying to solve? Then I want to talk a little bit about the case itself, talk a little bit about some of the strategic decisions. I know there's maybe some law students here. Some of the strategic decisions we made that we think were really important at the end of the day. A little bit about the settlement, and then finally just a little bit on what the legacy of this case is and what it means. So let me start by talking about the problem the case was trying to resolve. You know, all across Indian country, there are lands that are held in trust by the United States, both for Indian tribes and for individual Indians. In aggregate, that number for individual Indians is about 10 million acres. There was first an act in 1887 called the General Allotment Act, and it took the vast tribal estate and broke it into individual pieces and gave each native person, usually the man of the household, sometimes both men and women, 40 acres in some cases, 80 acres, 160 acres. The intent was to create farmers out of tribal people, even though some tribal people were already farmers, and others didn't want to be farmers. But this was the idea. But there was another thing about allotment. If you look at the congressional record when allotment was coming about, I remember one statement that still I can't forget to this day. It was a congressman, and he said, the problem with the natives is that they think too communally, and they've got to think more selfishly about themselves and their family. And that is what will lead them to success in our society. This is at a time where assimilationist policies were at the apex. So this was just part of a larger set of assimilationist policies, including taking children away from families, putting them in boarding schools that lasted for many decades. Almost immediately, the management of the trust was managed not for the benefit of the people who owned the assets, but for others, those who wanted to exploit the assets, and also to the federal government, state officials. There was a lot of collusion. There was a lot of fraud. In fact, one of the earliest reports was from 1915, so this is right in the heart of the allotment period, and it said collusion and fraud and institutional incompetence almost beyond the possibility of comprehension, end quote. So from the very beginning, we knew this system was not working, at least as a trust is supposed to work. Now, what do I mean by that? This will be one of the themes that I talk about today. A trust is considered the most sacred financial relationship in the law because it is one person putting their property in another person's charge. And that person is supposed to take care of it for the best interests of the beneficiary, the person who owns the property. So the trustee plays this really important role. And so there's all manner of duties that arise in the trust. You have to report regularly to your trust beneficiary. You got to make sure that you don't have a conflict of interest. You're always acting in their best interest, that you manage it competently. There's a whole restatement on trust that goes through all of the various rules that trustees have to carry out in this what the Supreme Court has called the sacred financial relationship. But yet from the very beginning, none of those things were happening. Literally none of them. They were colluding so that folks could lease these lands for much cheaper than any other lands, taking the oil where there was oil, taking timber where there was timber, paying pennies on the dollar. And so if you look, there was reports from the Merriam, first 1915 congressional report, Merriam report in 1926, the congressional record before the Indian Reorganization Act, reports throughout documenting with specificity all the breaches of trust that had occurred, were continuing to occur. And the thing about it is those of us who grew up in Indian country, this was not theoretical, right? We saw this ourselves when our grandparents went in to find out basic information about their account, their own account. Think about going to a bank and asking what the balance was and not being able to find out what the balance on your account is. Think about that as an idea. And that's just a regular bank account. This is a trust account. And so we all could see it. And then there became an effort led by a Blackfeet woman named Eloise Cobell, working with some tribal leaders, to try to change that. And so they started an organization called the Intertribal Monitoring Association that was monitoring the trust. And in the 1980s, she came from a financial background, Eloise did. And so they tried to work with the department. They tried to work with Congress. Congress ultimately, under Mike Sinar, Democratic congressman from Oklahoma, did a report after hearings that lasted, I think, 16 months, called the Misplaced Trust. Very influential report, issued in 1989. Documented all of the then existing continuing violations of the trust between the Department of Interior, the Department of Treasury, and individual Indian trust beneficiaries. So the Eloise and others with her continued to work on this problem. They went to the government. They went to hearings. And then there was a fateful day in 1995 when Eloise walked into a meeting with the senior Department of Interior officials and was explaining that they hadn't done what they needed to do. And Eloise was told, well, then maybe you're just going to have to sue us. And for those who don't know anything about Blackfeet, that was not something he wanted to say, because it was going to happen then. So she then came to us at the Native American Rights Fund and other lawyers and asked us to sue the department. Now, this was not a case that the Native American Rights Fund took easily. And the reason is because it was potentially massive. In a case this massive, it's very important that you think through all the ways to narrow the case, to make it smaller, because a massive case will just make it more difficult to prevail. But in some ways, it was just too big, maybe even too big to bring. It was certainly too big to bring in how all of these breach of trust, because there had been breach of trust cases brought principally by tribes, and when they brought those cases, 201, they were brought in what is called the Court of Federal Claims. See, when you sue the federal government, you have to bring any claim that's seeking equitable relief or administrative relief in the federal district court, the normal court, federal district court of Montana, federal district court of Washington, D.C. But if you're suing for money damages, that means you want to have compensation for a loss, then you have to bring that action in the Court of Federal Claims, one specific court in Washington, D.C. But at the time, it was near impossible to get a class certified in the Court of Federal Claims, much more difficult than the federal district court. So much so that I think when we looked, a class had not been certified in the Court of Federal Claims for almost a decade. So near impossible. So Eloise came to us, and it's actually, interestingly enough, about the 30th anniversary of when we met. We met in like October, November 1995. We ultimately brought the case in June 10th of 1996, because we had the time to research, and we knew the challenges with this case. So, dealing with this daunting task of the Court of Federal Claims, we tried to start thinking outside the box. So, desperation is the father of invention, or some words to that effect. Necessity required us to look elsewhere. How are we going to get into the federal district court, where trust cases just were not brought prior to this point? So we looked at it, and we thought that we could get a class certified if we had a cause of action in the federal district court. And so we brought an action not for money damages, not to get compensation for a loss, but to get an accounting, which was an act of having a court dictate to the Department of Interior how it had to account for the books. Now, the beauty of this is that one of the clear duties of a trustee is the duty to account. It's in the restatements, it's in Scott's on Trusts, and all the treatises. One of the most clear duties is the duty to account. So we thought this was the strategy, and then we could get a restatement of the accounts after the accounting was performed, because when the accounting was done, it would demonstrate clearly that the beneficiaries did not receive the benefit of their assets, and therefore the accounts would have to be restated. The fact is that the fact that we couldn't file in the Court of Federal Claims, or didn't think we were likely to succeed on the class certification, forcing us to go to district court, was one of the key reasons why the Cobell case was ultimately successful, for a variety of reasons. One is that the Court of Federal Claims is a court of grace. It's the sovereign the sovereign being the United States, gracefully allowing you to sue it. And so all issues are construed against plaintiffs and for the benefit of the sovereign in the Court of Federal Claims. The federal district court, the normal federal court, is a court of right. You want to go enforce the Bill of Rights? You go to federal district court. That's where it happens. You want to have civil rights violations? You go to federal district court. And so federal judges in federal district courts tend to be much more open to plaintiffs' cases. The other thing about it is that it was natural for us to bring this action in the federal district court the more we looked into it. Now, I'm going to get a little wonky here, but trust law is considered a law that arises in what we call equity. Way back 150 years ago, there used to be two court systems, basically, a court of law and a court of equity. Those were ultimately merged for most litigants in most instances. But those two, they played different functions in the legal system. Mostly, a court of law within civil court of law was about compensating for a loss. So you get in a car accident, you have a tort, you bring that in the court of law. If you want to stop somebody from doing something, or you want to require them to do something, then you brought that in equity. And trust is a creature of equity. The district court is a court of equity and law, but vis-a-vis the U.S. government, it's a court of equity, because your legal claims have to be brought in the court of federal claims. So it was very natural, even though it hadn't been done before, for us to bring this action in the court of in the federal district court in Washington, D.C. So we had 5 named plaintiffs. Eloise was the first named plaintiff because she was the engine of this case. And I want to be very clear about one thing. When you, oftentimes, lead class plaintiffs, class representatives sometimes they're referred to, are putative in the sense that they're figureheads. They're not really drivers of a case. That is simply not the case in the Cobell litigation. Eloise Cobell was the driver of the Cobell litigation. The attorneys like myself were merely the tools to achieve the ends as she designed them. That's very important to understand, because there, in my mind, are 2 important heroes in the Cobell case, and I'm going to talk about the next one momentarily. And Eloise is the principal one, because it was her strength and her perseverance that both led to the bringing of the case, the sustaining of the case, and the ultimate victory in the case, the measure of justice that was achieved. So we filed the case in June of 1996, and I like to tell this story because I think it demonstrates how we all have room to grow. We filed the case, and back then there was no internet. You couldn't go and find out, okay, we got this guy, Judge Roy C. Lamberth. Who is he, right? You can go to Westlaw, you start reading the cases that he's involved in, maybe do some news searches on Westlaw. There's no Google, no Yahoo, none of that. So we start researching Roy C. Lamberth, and I find out that he is a Reagan-appointed judge, worked in the Reagan administration, known as a very strict conservative from Texas. And my Berkeley, California brain was saying, this is not good for us at all. This is not a good judge for us. And he was the second hero of the Cobell case because he was a very good judge for us. He saw the injustice of the system. And he saw it from a place of, the United States is too great of a country to be treating these Native people the way they're being treated in this circumstance. One of the things that I think also led to our success is that we decided very early on a very specific narrative. And that narrative was, a trust is a trust. It doesn't matter if the beneficiary is a Native person or a beneficiary is a rich white person in New York City. A trust is a trust, and the same rules apply. It was simple, and we knew if we could establish that rule, we win, because they never abided by any of their trust responsibilities. So if we can establish that this is a trust like any other trust and the normal trust rules apply, then we win. And I think Judge Lamberth saw that and agreed with that. I will tell you later, after the case was settled, I wrote him a letter, and when I explained to him how when we pulled his name, I was not happy about it. I explained why. and some of the prejudices I may have been brought to the table at the time, and how the fact that he saw the injustice, but also had the courage, because I'm not sure every federal judge would have had the courage to hold, in fact, no federal judge had ever done this before, 2 cabinet officials in contempt of court for breaching their court order, shutting down the Department of Interior's internet systems because people could break in from the internet, get into accounts, change those accounts if they wanted to without any trails. So he was courageous to do those things, and because of that, I wanted him to know that in and of itself, helped me grow as a person, because I saw that initial prejudice was something that I probably ought not to have had. So we brought the litigation in '96. We went to trial in the summer of 1998, and Judge Lambert held that the United States was in breach of trust and failing to do the accounting that we had requested ever. That was in December of, we went to trial in summer of 1999, and the decision was December of 1999. That was appealed to the Court of Appeals. The D.C. Circuit ultimately affirmed that in all material parts, and agreed with our conceptual framework that a trust is a trust, no matter who the beneficiary is. And that decision is replete with references to basic fundamental trust law that would be applied anywhere, in all places, in all states, about what the duties are of a trustee. So then we went into the sort of dog days of the litigation, which was the grueling period between the affirmance in 2001 through the Bush years, and they were not really interested in trying to settle the case. We made a lot of efforts to try to settle it. They did a few things that were tough to deal with. They wanted to have Indian country and tribes turn against the case, and some did, because they would use these tactics of saying, oh, we can't do those normal services that we would do for you because of the Cobell case. We got to do this because of the Cobell case. We can't deliver checks because of the Cobell case. So a whole series of things that the Department of Interior did that in order to use their powers politically against the case, try to force us to settle for pennies on the dollar. And so we litigated a number of contempt proceedings. In the law, there are cases use Roman numerals to indicate and distinguish when there's a series of cases. How do you distinguish one case from another? Because they're the case names. Cobell v. Norton, Cobell v. Clenthorne, Cobell v. Salazar. But Cobell is always the first name. So how do you distinguish those? They use Roman numerals. And I think this is an interesting thing about the Cobell case, is that at the end of the case, the last decision, this was the affirmance of the settlement, was Cobell XXVI, Cobell 26. There were some 80 published decisions in the Cobell case. The case went back and forth between the federal district court and the Court of Appeals. Ultimately, the Court of Appeals removed Judge Lambert for bias, which is shocking, since his bias was because he found out facts from the case. But nevertheless, they found out, they said he was biased, and removed him. And again, part of the challenge with bringing a case of this nature, the historical case, is that courts are just really not very good at dealing with them. They just don't have the tools to deal with them. And they also are reluctant, the D.C. Circuit, the Supreme Court probably as well, to do justice, which would have been billions, probably tens of billions of dollars, to actually bring justice to the class of beneficiaries, class members of the Cobell litigation. So we established that there was a breach. They tried to do an accounting. They failed to do the accounting again and again and again. And that just went back and forth between the courts until 2009. In 2009, the D.C. Circuit overturned a decision by Judge Robertson awarding $500 million that we appealed and the government appealed, so nobody liked that decision. And the D.C. Circuit just sent it back down. And to his credit, Ken Salazar, who was then Secretary of Interior, directed his solicitor, Hillary Tompkins, to work with the Department of Justice, and for the first time, really try to get this case resolved. So the person that led the government's team is now my law partner. Things like this happen in Washington. His name's Tom Pirelli. He was Associate Attorney General at the time. And so we negotiated the settlement. He on behalf of the United States, me and one of my colleagues, Bill Doris, on behalf of the Cobell class. But let me tell you, even then, particularly then, Eloise was at every point driving that process. Remember, during this entire time, she was held up to Congress on numerous occasions to give testimony. And she did so time and time again. She was the face of the Cobell case because it was her case. She was the one that was prepared to stand up and fight this fight when literally nobody else was. And so we sat down in the Department of Justice, and over a 3-month period, we were finally able to put together a settlement for $3.4 billion. Then, I think still today, but I'm not sure, then the largest settlement of a class action against the United States in U.S. history. Much of that money has already been distributed to the class. There's about a $60 million scholarship, and I saw in one of these signs there's a Cobell Scholarship. That was created as part of the settlement of the Cobell case, $60 million scholarship, because Eloise said that she wanted something that would benefit the next generation. And so that was our attempt to do that within the confines of the Cobell settlement. There were some challenges to the settlement. If you're going to have a class of 500,000 people, not everybody's going to be happy with it. But in fact, point of fact, there were only about, I think, a little less than 100 people that objected, which is not very many on a settlement of a class this large. And ultimately, you have what's called a fairness hearing. We had the fairness hearing. Judge Hogan, which is the third judge for our case, basically said that the settlement was fair. In his view, he did an entire analysis, and that was affirmed by the D.C. Circuit. It went to Congress, and Congress, after debating it for about a year, ultimately agreed and passed the Settlement Act, signed by President Obama in December of 2010. As I look back on it, on the near 30th anniversary of bringing the case and close to the 15th anniversary, I think, of the settlement of the case, what I think about, because Eloise died shortly after the settlement, shortly after the months, literally months after the settlement was finalized and Congress passed the Settlement Act. She and I were going around Indian country talking to beneficiaries to make sure they understood what the settlement was about, answer any questions. And a few months later, she got cancer and she passed away. Some elders said to me when I was at Blackfeet that, this was one of her principal purposes to be here, to make sure that justice was achieved, and then the Creator took her. When I think about the Cobell case and what its legacy is, I think about it in terms of the message it sends to Native people everywhere in this country and in other countries as well, indigenous people elsewhere. I think after you go through a history of so much loss, so much trauma, you forget how to win. And what winning takes is perseverance. That's what it takes. It takes perseverance, it takes strength, because there are going to be people that try to stop you. There always are. So she gathered a team. Part of this, I think, was providence. We could have ended up with a judge that wasn't Judge Lamberth, but we didn't. We ended up with Judge Lamberth. Part of it was we happened to build a team that was critical in working together. Not that we didn't disagree. We did, a lot. But I think we came from different perspectives that were key to driving the case in a positive direction. And so I think that the message, I'm going to stop here and I'm going to say there is a code word that we have to provide for those who are needing CLE credit. And that code word is Lamberth, Lamberth. I think I got the sign that was enough. So, you know, if you look at how things happen in history, right? There's oftentimes, usually, somebody, an iconic figure, the person that refuses to get to the back of the bus, the leader that says, I'm going to march in India to make salt in the ocean, even though it was illegal, with millions of others. There's always a figure like that. And for Indian country, on this issue, that figure is Eloise Cobell. That's who we celebrate today, because she had the strength, she had the stick-to-itiveness, she had the perseverance, she had the power to see this through, to see this daunting fight, feel the fear, do it anyway, and bring a measure of justice to tribal communities throughout this country. Thank you. So with that, I think we have time for some questions.
Does anyone have questions? I can bring you the mic so we can all hear you. Any comments or questions?
I have a really short question.
Okay, that's fine.
And a good voice. Just when did it start? The start of the whole case?
Oh, yeah, we filed the case in June of 1996. So next June is going to be the 30th anniversary of the case.
14 years from then until the actual kind of what you call it done.
Right.
Well, and just to go along with that, what surprises me about this, I didn't know much about this until now, but what surprises me is how recent this is. So this trust had been mismanaged since 1915?
Even earlier. That was the first report, was 1915.
So from 1915 until finally a
Right.
settlement, those many years later.
Right.
And it took this one woman to recognize that and make it happen. Had other people along the way recognized it and just hadn't been able to make it happen?
Yeah, I mean, I think that many people knew. I mean, I think all of us knew. You know, like you couldn't grow up in Indian country and not know, because you know your family had these individual Indian money accounts, and they couldn't get information from the Department of Interior. They couldn't get their balances from their accounts. They couldn't take their own money out. I mean, just all kinds. I'll tell you a story. This is early on, but just it gives you a sense of the abuses. I'll tell you two stories actually of the trust. You know, it was mismanaged later. Earlier, it was used as a tool for oppression. And I'll give you two stories. First is about Jim Thorpe. Jim Thorpe makes the Olympic team, and he has an IIM account in Oklahoma. And he writes, as everybody had to at that time, because he's considered incompetent, right? He writes to just because he's Indian, if you're a certain amount of Indian blood, you're presumed incompetent unless you prove you're competent. So he writes to the superintendent who controls his money and says, I have made it to the Olympic team, and I am going to go, I think it was Norway or Sweden, something like that. And I'm going to need some equipment that the U.S. is going to pay for my travel and everything, but I'm going to need equipment for like running shoes and things of that nature. And the superintendent writes him back and says, Mr. Thorpe, you should be learning how to be a farmer instead of gallivanting across Europe. And then he goes on, of course, and wins the decathlon. So it was a tool of oppression in the beginning stages. It was a tool to extract resources from Indian country with little payment. Another story. This has happened to many people, unfortunately, during World War I. NARV tried to bring a case on this in the 1980s, and it was beyond the statute of limitations. But what would happen is young native people with IM accounts and with trust lands, they would go and join the military and fight for on behalf of the United States in World War I. And while they were abroad, it's happened in Oklahoma quite a bit, local officials with local banks and the local BIA officials would determine that they were competent, and they would give them the certificate of competency. Well, when you get a certificate of competency back then, what that meant is that your lands get taken out of trust status. So they're no longer not taxable, they're no longer inalienable. They can be taxed and they can be alienated. And so they take the lands out of trust, and before the person comes back from fighting in the war, they wouldn't have their lands anymore because they've been lost because of the failure to pay taxes on them. So just think about this was not constructed as a trust in the way a trust is supposed to be. It was a trust in name. And what we tried to do, and what I think we did do, is change it, at least in part, from a trust in name to an actual trust in which the interests of the beneficiaries come first.
Talk a little bit about the IAM accounts and the money that was in it, where it came from.
Sure.
And I always wondered if the companies paid a fair share, because that's all we could go on was the IAM account. I mean, the money that was in there. We never knew whether they actually ever paid, the person that leased it or...
Yeah, no, I mean, we know that they didn't pay a fair amount. In fact, we did an analysis on rights of ways, and we picked a couple of different reservations. And I remember distinctly on the Navajo reservation, the average, so the way when you have a right of way, the measurement for a right of way is called a rod. And so you pay based on how many rods you have. So the real price point for that is how much per rod. And on these pipelines for oil extraction, if you went to the line of the reservation, one side of the reservation line, the average payment was $9 to $11 per rod, and off reservation, it was between $47 and $95 a rod. So just think about, and this is not ancient history. This is like present day when we were litigating the case in the 1990s. So we know that they didn't get it, and back in the day, they really weren't getting anything. You would get these deals in which they just didn't have any negotiating posture. I mean, there's a famous case where the Secretary of Interior went to the Navajo Nation and said, "You will take 12% royalty, even though others were getting 20% royalty for the same type of crude oil." And the reason he did that is because he was lobbied by the company to do that. So look, we know that they didn't get it. Did it get better over the years? It got better. People did receive some money, but one of the reasons why trust law provides that you have a duty to provide information is so that you as the trust beneficiary at all times, with some diligence, can know what's happening with your property. Are you getting the right amount? Are you not getting the right amount? But if you're denied the basic information, then you simply can't do that analysis. And so whether it's forced, whether it's harvesting of trees in the Pacific Northwest or oil and gas in Oklahoma or Wyoming, whatever the resource is, the Indian valuation, the on-reservation valuation tended to be a lot lower, whether it was a right-of-way or what have you. Yeah.
Can you address the amount of money and how that came to be? And then also, I'm interested in finding out about what's happening now. Are the checks going out?
So when you say the amount of money, you mean the settlement amount? Yeah, 3.4 billion. So I always, I want to always be very clear about one thing. I alluded to it earlier. If you look at all the taking of resources through the life of this trust, 3.4 billion doesn't come close to compensating the class. The way we saw it is that this was and this is how I look at litigation generally. I'm a litigator, but I look at litigation this way. Litigation is the art of achieving what's possible. What's possible is not always what's fair, what's right, what's equitable. What's possible is what's possible. And I think in light of us suing the United States, the way courts generally treat the public fisc, I think 3.4 billion is, yes, just a measure of justice, but it was near the maximum amount that we could have achieved. So, I am ultimately happy with that result, even though it does not compensate the class for all the losses. And let me also say this. I want folks to think about the way wealth works. Everybody here knows $1 today is not worth as much as $1 in, say, 1930. What could you buy for $10,000 then is a lot more than what you can buy for $10,000 today. Just the way money works. It's called the time value of money. And so think about how if you're robbed of these resources, your entire communities are robbed of these resources for generation after generation, for decade after decade. Think about what kind of financial circumstance that puts the tribal communities in. And so a lot of the problems that you see, or you used to see and see still some, but a lot less today, as I think tribes are on an upward trajectory. But many of these historical problems and even continuing problems are because of poverty. Poverty breeds certain bad things. And when your communities that are resource rich are robbed of those resources, robbed of the funds of those resources, then that is what causes, or that is what undergirds the poverty that you see and all the resulting consequences, negative consequences of that poverty. I think we have.
So one of the questions was, to follow up what Charles was asking, is how is it going?
Oh, yes. They've definitely have better systems in place. I think if you talk to trust beneficiaries, it's not perfect getting your information, but it's a lot better than it was prior to Cobell. There's a lot more rules that they're following. There's a lot more documentation that they're doing. There's still problems. And I'm not sure that there's ever not going to be problems. So there's probably going to be some subsequent litigation at some point in the future. Because of course, when something settles and you still have breaches after the settlement date, then the liability continues after that. So unfortunately, it is better. I'm not going to say it's not better. There's definitely systems in place. You can go get what the Interior Department will call an accounting if you want to. And let me also say this. I think one of the things the Cobell case did is to basically change the mentality in a lot of places about the relationship between the federal government and Indians. When I first got to Washington in the early 90s, the idea that you could have the Secretary of Interior be Native was just sort of nuts. I mean, nobody would have thought of that. Yet, just recently we had Secretary Deb Haaland, Secretary of Interior. We have, hopefully, Peggy Flanagan, who's Lieutenant Governor of Minnesota, will be the first woman senator, Native woman senator. I think that one of the things we see in many communities, and certainly I've seen in Indian country, is success begets success. And that I think success, whether it's in litigation or in politics or in economic development, success begets additional success. And where I see Indian country as more generally, and this starts from President Nixon's message to Congress in 1970, 1971, ushering in the era of self-determination. 50 years now, we've been in the era of self-determination. And if you look at where tribes are today, and tribal communities are today, they're better off than they were 10 years ago. And if you look 10 years ago, they were better off 10 years prior to that. And if you look 10 years before that, they were better off than 10 years prior to that. Indian country is ascendant. And I think in part, that's because of a variety of successes and the fact that tribes and tribal communities are able to chart their own destiny in the era of self-determination. Do we have one more? Yes.
About what you said, that question in accounting, which failed to get, does that mean they just didn't do it, or they did a bad job at it, or incompetence, or hiding, or what did you mean by that?
Yeah, so the question was, you talked about not providing an accounting, and was it that they tried to and didn't, or they just didn't do an accounting at all? And the short answer to that is they never did an accounting, which, I happened as a summer associate, actually. I went to school at NYU Law School, and I summered at a law firm called Davis Polk, big Wall Street law firm. And I got a couple of assignments from the trust department. This is one of the things that struck me, because who were the trust beneficiaries for Davis Polk? The trustees were banks. The trust beneficiaries were like the richest people in New York. That's who trust beneficiaries are: the richest people, and then Indians. And they would have an accounting done annually. So annually, they would provide this accounting to the trust beneficiary, just as a matter of course. Like, you get your bank statement, they would get their accounting, and it would say where their monies were invested, how they were, what monies were made, all of that. And that was detailed in accounting. This trust, since its inception in 1887, had never had an accounting. They never performed an accounting, not once, before we brought the Cobell case. And now they do something that they call an accounting. It's imperfect, but it's far better than it used to be.
I have a question. Please, said too, like, rich people have trust accounts and Canadians have trust accounts. So with the rich people having trust accounts, like those that have trust accounts, even if we deny, like the amount we're getting for our land, BIA pushes it through anyway. Does that happen? Do they have accountants who just tell them what to do, they just do it anyway? Or do they have say and control over theirs and we don't?
So one thing that's changed over the years, and it certainly is better enforced today than it used to be, is that for any lease or any kind of contractual arrangement today, they will seek consent of at least 50 plus 1% of the trust beneficiaries. So as you may know, there's a lot of these allotments have 50 owners, so they have to get 50%, more than 50% of those who own the land have to agree and consent to that agreement. That didn't used to be the case years ago, but it is the case today. That said, if you're not a landman or in the oil and gas business, you may not know what you're supposed to get for a pipeline going across the lands. What a trustee would do in that circumstance in the private sector is that they would hire an expert to be able to negotiate that so that you get the top dollar. And the Department of Interior doesn't do that, and doesn't do that effectively, even today.
Question, or maybe frame of a comment. I was studying the CPA exam right now, and one of the things that I look into is, the forensic aspect of this. The government, you have to remind me, I think the government, as it was told to me, and maybe you can elaborate on this one,
Yep.
And so my question is, well, I guess I was confused, how did Arthur Anderson, a hated public accounting firm, assign the U.S. government to oversee the trust?
That's a mystery to us. I mean, they just decided to hire Arthur Anderson. They were hired before the Cobell case started. They were hired, I think. Oh, sorry. So the question was, Arthur Anderson, which famously were the accountants that did the books for the Enron scandal, and you just mentioned another scandal, but I know the Enron was the main one. Was the accounting firm hired by the Department of Interior to do what they then called an accounting, but it was not an accounting. It was a reconciliation. And why is that important? They were just matching pieces of paper with account entries to make sure that they didn't find any known errors. But if there was no paper, they assumed that was correct, right? Which is the exact opposite thing you do in a trust accounting. In a fiduciary accounting, all presumptions are against the trustee. So if they cannot prove, say, a disbursement went out by some kind of piece of paper that said it went out, canceled check, something, then it is presumed to get paid out. But that was not necessarily Arthur Anderson's thing, because when you have a reconciliation, then the client defines what the reconciliation is. So Arthur Anderson's, I think, knew that what they were doing wasn't actually establishing much, but they took it anyway because they were a $22 million contract. So.
I was just wondering, you said earlier that this case was too big to take on, and I wondered if you could repeat more to what you mean by that. What makes the case too big, and how does that make it possible to litigate?
So what I meant by that, the question was, when I said this case was too big to bring, what I meant by that is that this case involves 500,000 people, so just big in numbers. But it also, when you're doing a class action, there's a term that's used, it's called commonality, that the members of the class have to share some things in common. And so in this case, of course, you had natives who had oil and gas leases in, Wyoming, Oklahoma, places like that. You had timber sales in the Pacific Northwest. You had grazing fees. And so the more people you had, and with the more different assets, then you may have trouble getting the class certified because there's not that level of commonality. So one of the things we purposefully didn't do in our pleadings is we focused this on the financial aspects of the case, because the shared thing was money. Money was being generated and money wasn't being taken care of. And so we could have made this as much bigger case, but we would have had to have experts. We'd had to have oil and gas experts and timber experts, and we may not have gotten the case certified. So that's what I mean is, like, when you have a case that's this big, you're not struggling to make it bigger. You're struggling to make it smaller so that it's ultimately manageable.
Hey, Keith, I have a question. I'm over here in the back. So I may have missed this in the opening. What was the scale? We're talking years, but from the beginning of the case through to the end of the settlement, do you know how many lawyers and law firms worked on this case overall? Because we're talking scale over years and the class itself, but it really gives you an idea of how big a case is when you start talking about how many different attorneys are working on this.
Well, it's interesting. So there was a solo practitioner named Dennis Jingold, another named Thad Holt, and then there was the Native American Rights Fund, and ultimately we brought in Kilpatrick Townsend, which was the firm that I ultimately went to in 2006. So on our side, at any given time, there were between 4 lawyers and 8 lawyers working on the case. At its peak, the government had, I think, 67 lawyers on the case. And you might think that that's an advantage, that they got so many lawyers, they can research all the issues. And it was a huge and massive disadvantage, because the record was so big, we knew the record cold, and we were always communicating with one another. So we were this small but team that just knew the landscape of the case. We knew which documents were where, we knew the record. We could stand up in court and make a presentation about the case because we knew the entirety of the case. We knew the record. And so when you have these, when you think about numbers, for the government, they had Department of Interior has lawyers on the case, Department of Treasury has lawyers on the case, Department of Justice had lawyers on the case, U.S. Attorney's Office for the District of Columbia had attorneys on the case. So that's how they grew to have such a huge amount of lawyers working on their side.
Any more questions? No? Where?
Were there any ramifications to any of the employees who were caught shredding Indian Native Trust account documents? Because if I recall, there was at one point in time a federal judge said that these documents are not in my court by Monday when they should have filed a bench warrant for the Secretary of Treasury to approve it. Were there any ramifications to any of those folks in Treasury?
Ultimately not. I think that one of the reasons why Judge Lamberth, who was the judge you're talking about, was removed by the D.C. Circuit is that the next step was going to be individual contempt trials for people at Treasury, people at DOJ who had made misrepresentations, and people at DOI. I think that the only real thing that happened, which was very good for the case because of the attention it got, and attention is huge in a litigation, positive attention for us, was that Judge Lamberth held in January of 1998, Secretary of Treasury Rubin and Secretary of Interior Babbitt in contempt of court. And that had been the first time that sitting cabinet members had been held in contempt for, I think, about 120 years or something like that. Like, I can't remember as I sit here today. So that accountability was real in the sense that they're politicians, basically, and that was a reputational hit. And they were very much scrambling after that. It's one of the reasons why it elevated the profile of the case, which was hugely important for our purposes as well.
Well, thank you so much, Keith, for coming and for giving the presentation.
Thank you.
I also forgot to introduce myself in the beginning. It's been a crazy day, but my name's Michaela Running Fisher, and I'm Eloise's great niece. My grandma is Karen Powell, her sister. Her and my other aunt are usually the supporters for this day, and we go back to the son and the sisters. We started this day in 2018, and it was kind of funny. After talking with my grandma and my family, we had a little poster board. And they said, well, how cool would it be if you just made this little science poster board and like talked about your auntie? And I'm like, yeah, that would be pretty cool. So right where we're sitting, there was a little table with a poster board, and there was no one around, just people would come in and out. And so I think going from that to this today, having Keith Harper, a really important figure in this case, coming here is just such a tremendous accomplishment for the day. And I also wanted to have the committee come up who has helped plan the day, the Eloise Cobell Committee. Gigi, you have to come down here, please. Carol, Carla. Carla, come up here. Phil. Anyone who has helped, please come up here. So with these amazing people, I wouldn't have been able to accomplish anything. Each and every one of them has gave their time and their effort tremendously to this day, especially this year with the tough times that we have had. They all pulled together, and everyone has picked up one another in every type of way, and it honestly would not have been successful without these amazing people. So please give them a round of applause for today. And also on behalf of the committee, we would also like to gift Keith a ledger art piece that was also created by Jesse DeRozier. He's a Blackfoot member, and he also is a ledger art master. So this is just a little inspiration that he drew up of Eloise and her legacy. So we wanted to gift him it for coming all the way here and just being with us and sharing his knowledge with us. It's really impactful. Oh, and Eloise's Indian name is Yellow Bird Woman. So on here, that will be a description of it and just the journey that she had throughout the case. Grandma, if you want to come up here too, I'm sorry. So on behalf of the committee too, we always try to implement family. And so we also want to honor my grandma on behalf of the family, a ledger art piece too, so she can also have a matching remembrance of Eloise along with Keith. So. And now we'll also have Sean Whitegrass come up. He's going to sing an honor song just to honor Keith and my grandma, the family. He's also singing Eloise's honor song that was dedicated to her, and so I'll let him take over the mic, him and Brittany.
Okay, hello. My name is Sean Whitegrass. I'm from Browning, Montana. This is Brittany Hunter, my wife. We're going to sing this song made by Jay Dusty Bull from Browning, Montana for Eloise Cobell. It's her victory song when she won. Yeah.
And I think with that will conclude the 6th annual Eloise Cobell Day. We also have appetizers. Please feel free to grab some food and just sit around and visit. You know, as a community, this is what we're made to do, to visit and mingle, make connections, but also just, I think that's what Eloise would probably want, is people to be here and reminisce about her day and just get to visit with everyone. So thank you so much for coming, and I hope you guys can come back next year.